Good afternoon. Welcome to the Call to Justice. I'm Amos Jones. I'm your host. And I'm pleased to welcome you to our inaugural edition of the Call to Justice. This is a program born out of a need for people to understand what's happening in the world legally from a theoretical position, from an intellectual position, but also from a spiritual position. And it's a show that spins off, sort of, from the show Culture, Class, and Consciousness that airs on this network on Friday evenings. I'm very grateful to Dr. Lionel Green, the station owner, as well as engineer Devin, for helping today launch our sojourn into this journey together. Today we're going to be introducing the format of the show, getting familiar with one another as host and audience, and then taking up some of the topics of the day, especially some of what the Supreme Court has chosen to do this week with regard to civil rights law and what we believe are abrogations. Let's start with an introduction about what you can expect here. This is your show. This is a program that's here to help viewers understand how things really work. Have you ever gotten a sense when you're watching the network news or your favorite YouTube persons who help to be thought leaders and help guide you in how you go about processing the information and analyzing the information we're being given through other channels and platforms? Have you ever wondered and felt that just like something's missing, that there's a larger meta-narrative, that perhaps a kind of worldview might help you to adopt in order to understand and to apply principles so that you on your own can more adroitly navigate a very perilous world? Many of the viewers of this program are African Americans inside the United States. Then we have a global audience on the continent of Africa and in Western and Eastern Europe. This is a global 750,000 subscriber network, and I'm sensitive to the global needs. I have served at times as a professor of law at a historically black college, North Carolina Central University in Durham, at a Baptist law school at Campbell University for 6 years in North Carolina, and then also as an academic visitor to the Faculty of Law at Oxford, and as a Fulbright visiting scholar at University of Melbourne. I have a global sensibility, even though our primary units of analyses are going to be right here in the United States at the seat of world power, Washington, D.C., particularly when it comes to the court system in this world power, because there's a lot of stuff going on in these courts that people are not reporting accurately or that they're not reporting at all. And if people were to find out what's really going on, which we're going to get into later in the hour, they'd have a lot to say about the problems that are being created by an unelected branch in the federal sense. And so I want us to really get comfortable revisiting some of the things that we've been taught, told, and presented as courts decide what we're going to do with these African American people. And there are global implications for that. To understand the way the United States interacts in its legal system internally is to understand the psyche behind the way our influence is deployed around the world in this most powerful country in the history of mankind. The Bible says, to whom much is given, much is required. And that means moral authority and moral values as well. This is WBGR, Believing in God Radio. That's what the call letters stand for. And so here we stand unashamedly on the Word of God. Our theme for this show, The Call to Justice, is from the prophet Amos in the Bible. Amos was an unorthodox prophet because he came up from Tekoa with what the late Bill Jones called the stench of sheep manure. And he started talking about the corrupt preachers and unjust judges. And a lot of folks, especially within these now professions, don't want to go there, but given the things falling apart in our world and the lack of an explanation, the call to justice is here to fill a void. And the wonderful thing is I'm a political independent and I'm an evangelical Christian Baptist. So I try to traffic in truth. Our theme is from Amos chapter 5, verses 23 through 24. It's a Judeo-Christian ethic for social justice. Amos of the Bible, the prophet of social justice. And he said, quote, "Take thou away from me the noise of thy songs, for I will not hear the melody of thy viols. But let judgment run down as waters, and righteousness as a mighty stream." Judgment roll down as waters and righteousness as a mighty stream. We're going to get into judgment and we're going to do rejudgment. Because a lot of the judgments we see that apply to African American people in the courts, in the political realm, and so forth, are not fair judgments, and they're not honest judgments. They're judgments that are devoid of the factual record and that animate a cruel fiction that African Americans can expect equal protection under the law. And that's what the mission of this program is, to open up what's happening to all of you out there. Open up the phone lines so that you can call and report and figure out, again, not legal advice here at all, but legal theory and moral theory. A consciousness from a faith perspective. I'm an ordained Baptist deacon. From a faith perspective, so that we can, with the lens of God, see things clearly and objectively and operate accordingly. We are weekly. We will air on time from noon to 1 Eastern time in the U.S. every Saturday. Most of the shows will be live in studio. Often we will have guests. I will interview guests for the benefit of the audience. I will consider the input. You can follow us on all the social media platforms. Go right now to www.thecalltojustice.tv. That's thecalltojustice.tv. www.thecalltojustice.tv. It's optimized for your smartphones, and you can click on any of the many social media buttons at the bottom of the page so that you can see what we're doing over the courses of these weeks, before the program and after the program. You also can sign up for our newsletter that's coming out starting in December. We're going to develop the newsletter in accord with what the audience over these first 8 weeks indicates the priorities should be. I believe that sound doctrinal legal thinking, as we pronounce it in the law, doctrinal is the typical pronunciation of the basic principles of law in the Western tradition out of the Anglo-American context. We believe that these doctrines should be opened up and that you should understand what's influencing the things happening to you on a day-to-day basis and in your lives. I believe that not a lot of people who have been legal scholars have made accessible, especially to the black community and the underprivileged community and the poor community and poor white people, whom I serve as a lawyer in another context, poor white people who have very little in the way of political clout or legal recourse working on their behalf. And that's why so many of them voted for Jesse Jackson 30 years ago, almost 40 years ago now, I guess, in 1984 and 1988. So people now are waking up with these independent, streaming sources of information from credible people who have a record of being on your side. If you want to turn the channel now, you're free to do that, but I will invite you back. I want you to look at the record of the people coming to you. When somebody is explaining to you what they think might make you better off, when they're listening to you and assessing in order to give some kind of viewpoint, some kind of theory of how you might be helped, consider the source. And I don't mean a personal attack. I mean to consider the record, the background. How many people did that person save their job for? How many people did that person intervene on behalf? How many people did that person pray for? How many people did that person contribute money to when asked? How many people did that person help out? How many people did that person stand with when it wasn't popular? If we ask those questions, then as any oppressed people, we can start to kind of figure out whom we might want to roll with. And that's why I chose this audience, a choice of platforms. But on balance, when you consider this network on this air, on the direct Roku streaming, where we have 750,000 subscribers, you find that it's a real group of people who call for actionable information. And that's what we're here to do. You may join me at the website, www.thecalltojustice.tv, and consider our genesis, if you will, how we got to be here and what we intend to do for you. Well, as we point out, this program will be live weekly. We're going to bring news and analysis every Saturday. We're going to set you up in the middle of your weekend such that you can really be in a good frame of mind for your religious observances, whether you come from traditions of Islam, Judaism, of course, Christianity, like me. But it's the middle of the weekend so that you're in a frame of mind of contemplation and out of the hustle and bustle of the workplace, which can be a horrible distraction when it comes to your thinking and ability to process. That's why I'm here, so that I can relax and sleep on what we call the run of show on Friday nights and really be here prepared, ready to receive you and to take these calls and to interact and to help the audience understand what on earth is going on and where they fit into it and what they might be able to do about it for themselves, their families, their loved ones, and everyone else. Today, we believe that there is a crisis of law. We see just in reports from Reuters and the Washington Post, just for example, that the Supreme Court of the United States is a boutique operation with a handful of in bed with justices, if you will, figuratively, former clerks and so forth, who are the principal aggregation of advocates who are allowed to go to the court. The mainstream reporters want you to think that your problem today is Justice Clarence Thomas because he took trips on a jet to faraway places. That might be an issue, but I would submit the real problem is who gets heard in court and who doesn't. And from the federal district courts where cases are dismissed because judges don't want disgraceful race discrimination fact patterns to emerge, either in court or within the law, all the way up to the Supreme Court, where basically we found from our data set, for all intents and purposes, black people are not allowed to come there if they are civil litigants on behalf of civil litigant black victims, especially professional blacks, seeking a remedy from some kind of white employer, police officer, or other type person. The Supreme Court is closed, and it superintends the entire federal court system. So if it's closed to us, and I'm about to prove how it is, when you understand news we're going to break right now, right after we introduce our format, we're about to break news about what the Supreme Court did when they refused to hear a case. And viewer discretion is advised. There's foul language, the likes of which have never come out of these lips ever, but it's at the Supreme Court, having been dismissed just this week in breaking news that deals with your equal protection as Americans, especially black Americans, and what the Supreme Court is not willing to look at. So let's continue before we get to that breaking news. Viewer discretion advised. It's very low, very, very low, the filings that had to go up to the Supreme Court that they rejected this week. As we prepare for that, let's again just think about the premises of this program. The inaugural offering of this show today does focus on a Supreme Court breaking news item from this week. And it harkens back to what happened in 1857 at the U.S. Supreme Court in the famous case of Dred Scott versus Sanford. To make a long story short, we had a slave who had really been freed under the law and who instead was repossessed, if you will, dispossessed of rights for all intents and purposes, basically, and who had the nerve to sue prior to any constitutional amendments protecting blacks at a time when slaves were 3/5 of a person, and the question was whether his rights could be vindicated as a freed person who had been essentially re-enslaved. The Supreme Court said, no, you don't have any rights. White people don't have to respect black people's rights in America. And that law lived on because the 9 justices decided that that's the way they were going to make the law, notwithstanding the protections in contract law in the state of Missouri, near St. Louis, in the region in and around St. Louis, where this case materialized. So that was an 1857 court decision thought to have been disposed of because of the Civil War, which occurred because of black people. And the need to make the country live up to its ideals on paper by having a civil war to stop slavery and other things and state abrogations of fundamental rights that we thought we had espoused at the time of the Declaration of Independence in 1776, but that had never been actualized in any real way for the masses of African Americans. So what happened was the Supreme Court came, and after that, after 1865, when the war ended, there were a series of constitutional amendments and civil rights statutes that the good people of America enacted by popular vote or by representative democracy or both in order to fix the country once and for all. And it was working beautifully until the civil rights cases where angry white people decided to re-enslave black people under the law for all intents and purposes and started challenging the civil rights statutes and pretending that the civil rights constitutional amendments, 13th, 14th, and 15th, did not mean that black people had to be taken seriously as citizens with full rights of such in this country. So the Supreme Court gradually took away the effect of the 13th, 14th, and 15th Amendments for all intents and purposes in the civil rights cases. And they reinterpreted the civil rights statutes that Congress had passed, and they lay dormant for all of those 60 approximately formal Jim Crow years that began to really fall down with the 1954 decision in Brown versus Board of Education. That's what your Supreme Court did. So there's a history and tradition of the Supreme Court which never had a black justice until 1968, the FBI informant, Thurgood Marshall, which he was. Google it. Thurgood Marshall was an FBI informant. Of course, why else would they put a black man on the Supreme Court with an all-white review process that they like, until Sandra Day O'Connor became a woman on the court in 1981. So that is the backdrop of the culture of the Supreme Court. So the Dred Scott motif is always lurking in the background, but we believe that this week it burst into full public view. And I called the counsel in this case. I am DC chapter co-convener of the National Conference of Black Lawyers. And we looked at this case and determined to send a statement about this particular case I'm going to tell you about. Viewer discretion advised. The National Conference of Black Lawyers decided to jump on this case because it was such a horrible dismissal of a black man's case out of a North Carolina federal court that we knew, as black activist civil rights lawyers who have been on the vanguard since 1968 of the movement for black liberation, including defending Angela Davis to her full acquittal on those murder charges of murdering a judge, where she was nowhere near the courtroom and somebody used her gun and they tried to put the black professor up in jail. Ronald Reagan fired her and all that kind of stuff in those years. We defended her, and now we decided it's time for us to stand up because of what's happening in these federal courts that nobody seems to want to talk about. Well, today we're talking about it. And this case came out of North Carolina, and I'm not going to name the petitioner, but the case was dismissed by a Judge Terrence Boyle out of North Carolina, whom the Leadership Conference on Civil Rights has condemned as having racially discriminatory decisions for all of his approximately 40 years on the federal bench. So Judge Boyle sits there. He was denied promotion to the Fourth Circuit twice because largely of the racial problems and his intransigence when he was reversed in following the Court of Appeals and the reversals and the instructions. He's somehow rejected for the promotion and unfit to be promoted to a higher court, but he's allowed to sit there in federal court and rally and dismiss black people's cases after all that time, money, and heartache is spent, and these poor African Americans are coming into these courts thinking that Dred Scott died. Well, he dismissed the case of this black employee of an agency of the city of Greensboro or of the county of Guilford, North Carolina, which is where Greensboro is. And the case was dismissed, and the U.S. Court of Appeals for the Fourth Circuit dismissed it. This is a case brought by an incredible black civil rights attorney out of Charlotte, Sharika Robinson. And Attorney Robinson asked the court to hear this case in full, the Fourth Circuit panel court. She wanted a full. They didn't even let her come and argue the case. They upheld Judge Boyle. There's a black chief judge of the Fourth Circuit from Richmond. Didn't help. Up to the Supreme Court, Sharika Robinson went with this case of this employee who was harassed. Viewer discretion is advised. People who know me will tell you I don't curse. Never have, never will. But the Supreme Court petition includes the material that Judge Boyle and the Fourth Circuit, and now as of this week when the Supreme Court rejected this black man's petition for review of this mistake of law, Sharika Robinson alleged and argued in her petition. Now I have to get into it because it's the public record and it tells you where you might be as a black American trying to have rights up before some federal judges. Here is the question presented, and it may come up on your screen as I'm speaking. The question presented from the Supreme Court case that the Supreme Court declined to hear with a one-sentence rejection of the case is right here at the question presented, Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, and national origin. The Supreme Court holds that these rights apply to discrimination based on sexual orientation as well as race. This case had perceived sexual orientation, and it was largely a race case. Additionally, Section 1981 of the U.S. Code, which is an old post-Civil War Reconstruction amendment that had been dormant for those years, 1981 precludes discrimination based on race. In this case, the petition says, the United States Court of Appeals for the Fourth Circuit held that trigger warning, what this court lets happen. I have to read it so you know how bad it is. Use of the word nigger, calling a man boy, bitch, gay, and saying a man, quote, sucked D-I-C-K and got F-U-C-K-E-D in the A-S-S, quotation marks. This came out in discovery in the case. Saying all these things and saying that a man sucked D-I-C-K and got F'd in the A-S-S in the workplace, the Fourth Circuit and Judge Boyle say that's appropriately used in the workplace as not pervasive enough to alter the work environment or work conditions, among other insults. This is in the petition, the question presented to the Supreme Court. The Supreme Court is asked to review this. Is this really okay now in the United States? Is it okay to use the word nigger, call a man boy, bitch, gay, say he sucked D-I-C-K, he got F'd in the A-S-S? Is that appropriately used in the workplace? And it's unclear whether the man were even homosexual, gay, whatever term you would use for someone not identified. That's unclear, but the man was certainly black. It's a race case. So some circuits in the U.S. are saying, yes, some of these courts of appeal are saying that's not enough to get a case to a jury to decide whether there's discrimination at work. Of course not in good America. Other courts have said, of course this is enough to show that there might be racism. That means enough to get a case to a jury for the jury to decide. A lot of judges don't want juries to have cases because juries actually do the right thing most of the time. Way more than judges, in my experience. The people know what's going on. That's why they passed and voted for legislators who passed the Civil Rights Acts of the 1860s and 1870s and ratified the constitutional amendments and fought and won the Civil War. The people know it's these courts that somehow have this twisted, and they operate in the shadows because you couldn't get anybody to cover this case. Around the world, in Africa and in Europe, I want you to see and hear this. At this Supreme Court, where they want you to think that Clarence Thomas is the issue, when in fact it's not, it's Terrence Boyle. We're going to do a whole documentary on Judge Boyle, and we're going to do a documentary on the other Jesse Helms protege in another case that we've reported on that you're going to hear more about. My case, Amos Jones versus Campbell University, we'll have another segment on that another day. For now, this is about the Guilford County case in the Supreme Court. So the question presented was, and again, you may see it on your screen, whether the use of the word nigger and or nigga, calling a man boy, bitch, gay, saying a man sucks D-I-C-K and got F'd in the A, can be considered colloquial or teasing by a superior in the employment context. Or on the other hand, whether as Attorney Robinson has argued here, I'm all quoting her in the privileged Supreme Court document, whether on the other hand, those words are inherently offensive sufficiently to rise to a presumption of hostility, even if they're said by a person of the same or different minority and or affinity group, with the racial comments alone standing under Section 1981 or Title VII of the Civil Rights Act of 1964 as actionable and sufficient to get a case to the jury to look at the totality of circumstances and determine whether in fact there were employment discrimination. The Supreme Court threw this out. They don't want to deal with ordinary people, evidently. They want to focus on Texaco versus Pennzoil or other big money cases where big money former clerks come and bring these cases in what I have called the real original revolving door. The revolving door between clerks who go up under the judges for a year or two or three and then get $100,000 or more to take those talents into a law firm that pays them a big check because they were with the judge so they can go before these judges they've been before for their career and argue cases before the judges or understand the judges. That's the revolving door that unlicensed former law students in many cases come out at 23, 24, 25 years old in most cases, 26 years old, and get to work for the judge and become friends and go to picnics with the judge and dinners for the rest of their lives, these like-appointed federal judges, socialize and fraternize, then go argue these cases before them with those nice big bonuses. No wonder there's only one black person who regularly argues at the Supreme Court out of all the litigants. Read the Washington Post's October 2022 expose on the bleached Supreme Court bar. I'm admitted to the bar of the Supreme Court and have been for about a decade. I had 3 petitions this term, and 1 petition several years ago. They're never going to grant cert if you weren't in that revolving door, according to Reuters and the Washington Post. Inferences to be drawn from there. We're going to get into that later on this fall. We're going to get into a lot of things this fall. But today we're focused on that breaking news. The Supreme Court turned out Attorney Robinson and her client out of hand. And it's a terrible, terrible thing. Terrible, terrible thing. So on this program, we're going to bring these actual documents, privileged documents sworn by officers of the court, civil rights attorneys. We're bringing them right in here. We're going to get into it. And we're going to get into a lot of other conduct that a lot of tortfeasors, evildoers, and discriminators think they can go into a court and hide and sanctify the way this defendant has done in fighting and defending this case. Some people know that they have the kinds of judges where they can go and make anything look washed white as snow. But we're going to show the guilty stains on the call to justice. And we're naming names. It's time to tell the truth. It's time to hold these people accountable. They're your neighbors. They're your fellow church members. They're your fellow blacks, some of these judges. And they need to stop trafficking in these black ones. They need to stop trafficking in their blackness, getting these appointments based on the blackness, and turning around and acting like a chocolate-covered white supremacist. We're going to look at their records. Look at Justice Ketanji Brown Jackson. Oh, who we thought, oh, a sister girl. Her hair's kind of natural. Ooh, the sister. Come to find out, according to one critic of hers, she dismissed 27 of the 30 black employment discrimination cases and refused to let them go to a jury in her case. And a black Alabama judge said that she wouldn't certify the results of a class action that would have been good for him and the class, and he's a black attorney, that she went out of her way, according to him, to take his victory and notch it down. So I don't know what good it does to be a black lawyer and to claim you're for Thurgood Marshall and to show up in 16th Street Baptist Church in Birmingham, which she just did, on the 60th anniversary of that bombing, where the Ku Klux Klan, which had a lot of lawyers in it, and police officers in the South, the Ku Klux Klan. We're going to talk about Ogletree Deacons law firm as well. There are 2 lawyers there who have refused to answer my written emails in recent months to identify whether and to what extent members of Ogletree Deacons, a major discrimination defense law firm of primarily white attorneys, whether they have partners now or in the past who were in the Ku Klux Klan. These 2 attorneys will not answer the question. Their material is going out in the coming days through our social media to show why won't they answer the questions in 2023. Who was in the Klan in your firm? This is the way it looks. This is not imagined. Read the Supreme Court petitions. These are the types of materials that are going to be reproduced in our newsletter so that you can really find them, because you're not going to get this on MSNBC. You're going to get to Ketanji Brown Jackson, the black Nubian queen. They're not going to get into her 27 dismissals of 30 of the black people's serious matters. And let me tell you something. I want you to call when these lines open, and the lines are opening now. I want you to call in, because the fact of the matter is that when you really look beneath the surface and you get surface reporting in these mainstream networks and you go to the documents, you find there's a whole shadow world operating of black people and others, poor whites, who are being denied their rights. So much so, I've learned that poor white people don't even bother to go to court. Black people do. They find a good civil rights attorney and think that they're going to prevail like in the movies. Civil rights practice has been called God's work because the courts are so against you most of the time. And of course, I succeed frequently. I'm a lawyer and practice civil rights law, but the way in which we have to build and bring these, and the way we have to appeal every darn thing, that costs lots of time and money and years. And often, as we just saw at the Supreme Court, a white supremacist mindset keeps the discrimination going, and we're right in Dred Scott, and nobody bothered to tell you. Don't fall for the head fake. You need to tune in, listen up, call critically. I will debate anybody, anywhere, I invite the white people at Ogletree Deacons. They run from me. I invite Judge Rich Leonard, who's Dean of Campbell Law School, and how he was rolling with Thomas Farr, who used to work at Ogletree Deacons until Ogletree Deacons got sued under the Ku Klux Klan Act, and suddenly a few days later, in 2021, suddenly Thomas Farr, after all those decades, left. He's the voter suppression defense attorney who went to the Fourth Circuit and was told that districts drawn by Republicans that are surgically drawn to discriminate blacks out are unconstitutional. That Thomas Farr, that one. Rich Leonard, the dean of Campbell Law School, who's supposed to be a liberal, rode around with him. I will have links to the video where we exposed that and demonstrated against that. So this is the system where a liberal progressive black woman and a liberal law dean and all that. Stop with the labels, folks. This is 2023. You need to look at the content of people's character, whether they be black, white, Asian, Hispanic, whatever. Women, men, whatever their identity is, you have to go with the record. You have to find what they say and what they do. And that's what we're pulling out here into the record on the call to justice, and you will be empowered. And you get to call in. Go to the calltojustice.tv right now. You can upload documents in your own matters across the country. Not for legal advice. I am not giving legal advice here. We are doing legal theory and giving you a meta-narrative, and it's the Dred Scott meta-narrative that just came back in the Sharika Robinson brought case at the Supreme Court of the United States. Out of the Fourth Circuit that's complicit in this. And Judge Boyle, whom we're having a whole documentary on because of his record with these black litigants. It's atrocious, and they're running scared like rabbits in North Carolina. Sharika Robinson is not scared. And we have her back. I will provide paper trail evidence of the National Conference of Black Lawyers and what we decided to do to support this, fighting back on this Dred Scott and all this profanity that they're allowing now against black litigants. You heard it here. You're going to get it on the website and on social media platforms. It's coming out. The public needs to know, the world needs to know. To my African viewers, we've got nearly 1 million folk around the world, and a bunch of them are on the continent. Don't let anybody come over there trying to help you with your civil society reforms. Rich Leonard, the dean of Campbell Law, whom I had to sue for race discrimination, who rolled around with Thomas Farr, who just demanded that school just demanded that I pay them $7,000 cash when I'm the victim of the discrimination. They're holding my converted property that we have photographic evidence of in a conversion. But yet he's going to go to Namibia, this Rich Leonard, for those periods and tell the Namibians how to set up their court system. After he served over 5 decades in that same all-white courthouse, the Eastern District of North Carolina. Guess what? Watch this. Where Terrence Boyle and that nigger BITCH F'd in the ASS, nigga, we can do this to you case came about. It's back. Dred Scott, I don't think it ever left. Now that I can assess the conduct of Campbell University, and let me make an appeal to Campbell University. We will have a hymn of invitation at the end of this broadcast today, and everyone, if you read thecalltojustice.tv and you check on our social media platforms, you'll see we will be having a hymn of invitation because these people need to be called to repent before it's everlasting too late. One of the hallmarks of traditional Christianity around the world and of evangelical Christianity is that Christ gives us a choice. You can follow or you can refuse to follow. And we believe that for people who persist in their unrepentant, unmitigated evil, which racism is a part of, racism is an idolatrous heresy. They would tell you that. The liberal Episcopalians, like where Rich Leonard goes to church. Well, they will tell you that if you don't repent, my brother, my sister, you're going to burn for eternity in a burning hell. I didn't write it. The apostles wrote it. God warned of it. And, you know, the path is straight. You got to be on the straight and narrow. There is no room for racism and white supremacy on that path. So you better get it straight instead of crooked. The call to justice is here to help us make crooked ways straight and to have a level of accountability. Time now has come for us to take a break. When we come back, we will open the phone lines I will put the phone on the desk. We will take a 60-second break for an advertisement. The advertisement is coming as we take a break and open up the phone lines, and I'll be mentioning some other matters that are now under investigation here at the Call to Justice. Or no, don't come. I gotta get back. Welcome back. The call lines are open, and we have a caller.
From V. Jones, Lamont.
Good afternoon. You're on air with the Call to Justice. How can we help? I'm sorry. Could you start over? Yes, you're on the air at the Call to Justice.
Can you talk a little more about the mission of your show? It's so needed, and what you'll be bringing us in coming weeks. Thank you.
The question is, this show is so needed. The caller is so glad that I've come forward to help this audience of the world figure out what's going on. And he said, what's in the coming weeks? Well, I'm glad you asked. I have a list of 16 topics that we are already investigating and working out reporting on so that we can bring you factual reportage along with this theoretical analysis. One of them involves a very serious under government investigation down in Kansas City. Osteria Il Centro, which is owned by Minsky's Pizza, is caught up in a government investigation for race discrimination. And my sources are telling me in Kansas City that it's a black full professor who was racialized. And that investigators at the government agency found that this Osteria Il Centro, owned by Minsky's Pizza in Kansas City, does not even have proper postings dealing with discriminatory regulations or regulations of anti-discrimination law. So I'm very concerned, and we're following that story. And our sources are telling us there's a University of Missouri location here. So I have some calls out on this Osteria Il Centro, Minsky's Pizza discrimination investigation. Now, we know that you're innocent until proven guilty. But the standard in the civil realm, like discrimination, is not innocent until proven guilty. It's preponderant evidence, just like the Supreme Court case I just told you about. So it's a much lower standard. All you have to do is prove it's more likely than not that it was discrimination. And given the history of the Supreme Court, with their bleached environment, and they're having only one black regular arguing there. He argues on behalf of rich white people who go to Williams and Connolly and big old international corporations who use Williams and Connolly, which was Elena Kagan's law firm. She's a woman, Justice. She was my dean at Harvard Law School. She was an outstanding dean. She's a decent justice, too. I like Elena Kagan. I would recommend Elena Kagan. She worked at Williams and Connolly, so there's a distinguished black lawyer there who is excellent. And according to the Washington Post reporting, he's the only Negro in the Supreme Court arguing case out of all those white folks. So it seems like there must be a colored entrance because they shot down Sharika Robinson. And I'm told, and my understanding from the case is it's a black law enforcement officer whom she was suing on behalf of that Terrence Boyle shot out of court and denied a jury trial. In the Fourth Circuit, where the chief judge is a black man, nobody even voted to rehear the case. Out of the whole panel, about roughly 15 judges. I don't know what they're doing there. So that's one of the matters, Osteria El Centro, in civil rights drama in Kansas City. We're looking at you. Another one is, we're looking and reviewing Denise Clark. Denise Clark is a black civil rights attorney in Washington, D.C., who was slapped with ethics charges and publicly disciplined. Look it up. Denise Clark is out here. She was found guilty of missing a deadline in a civil rights case and still trying to take money and lead on a client. And I guess my recollection is that she was found, it was incompetence and probably dishonesty or something. I'll look at we're going to bring that to you. This Denise Clark, this black, ill-equipped civil rights attorney, according to the bar, what they have on her, they published it. She's represented by Carr Maloney in that case. Pull that document. Pull the discipline on Denise Clark. She's out here looping in other black people at the Office of Human Rights, which we're going to get to. She represented a Nikki Peel. Nikki Peel went against building bridges across the river. The defendant of Nikki Peel was Carr Maloney. That was their lawyer. Carr Maloney Law Firm represented a black against
call from the
building bridges across the river. Her own,
call
Denise
from
Clark's
the
own
Lydia.
Her own
call from the
lawyer in her ethics charges that she lost because she was publicly disciplined with an admonishment that you can pull off the disciplinary council's website and read it. And there's a Carr Maloney Law Firm. That was her lawyer. Then she turns around and she's supposed to go against Carr Maloney for Nikki Peel. It's at the Office of Human Rights. You can FOIA request Nikki Peel and building bridges across the river. We're doing a segment on all their discrimination, sex harassment, near trafficking and prostitution. Nikki Peel went straight to the media on this. She put me in front of the Office of the Councilman White in the oversight hearings of Office of Human Rights. Office of Human Rights, Nikki Peel is right on point. The Office of Human Rights, as she has testified on this, she's on point. The Office of Human Rights has gone about basically letting cases languish and letting your rights slip away. The Office of Human Rights in the District of Columbia just did it to another case we're bringing, and we're going to have this gentleman on going against Washington Children's National Medical Center, a black therapist whom persons inside Washington Children's National Medical Center tried to get a distinguished, renowned Nigerian-American black therapist, a man who counsels black families. They tried to get his license revoked in Virginia and failed. And we have the paperwork on Washington Children's. We're getting into it, and we're getting into it the way they did that family. Washington Children's, and this is a charge at the Office of Human Rights pending that we're going to get into. This is the other issue to answer the caller. This is another issue. Office of Human Rights has been holding and dragging their feet on the complaint by the black family against Washington Children's National Medical Center for demanding that the black family convert out of their historical Baptist faith, their nominally Congregationalist, generically Congregationalist faith, that they abandon that and get with the new religion. That's what they were told when their child was snatched and held and was not given back to them after what was going on inside Washington Children's National Medical Center. We have a blockbuster report coming on that and what Washington Children's National Medical is doing and some of the staffers we've named. That's the case that you saw on Culture, Class, and Consciousness where we broke news on this air last year. Go to stopcpssexchanges.org. stopcpssexchanges.org, and you will see what Washington Children's National Medical Center is being challenged on at the Office of Human Rights, which is taking their own sweet time. We're getting into the OHR. Thank you, Nikki Peel, for bringing that. I'm sorry you got caught up with Denise Clark, because it's about to pop really bad with regard to her being exposed for where she is not supposed to be, in our opinion. So the legal theory of conflicts of interest have some of these lawyers who have been disciplined out here question and challenge for the same thing. And I'm happy to release the papers on that I am permitted to release under applicable law, so that you can be educated in the name of Jesus in this ministry. And that we can pray that you avoid lawyers like Denise Clark who get disciplined, and we'll have her file out there for you so you know it's we got documents out the river. Everything's documented. We don't have to make it up the way these judges do when they dismiss black people's cases. And I have to get them reinstated on appeal. It's terrible. We're looking at a Carr Maloney. Yeah, we're looking at them and how they're able, why they think they can fight Nikki Peel and while defending her lawyer in that other case from before. And now they're holding money and trust, so-called trust, caught up in an arbitration. So we've got some issues. It's a shame to have to blow the whistle because lawyers won't follow the ethics, including people who claim to be for you. So you've got to watch out for people like Ketanji Brown Jackson, the Chief Judge of the Fourth Circuit, and according to the D.C. Disciplinary Counsel Office, Denise Clark, and what she did to that black client whose case got dismissed because she filed it late, according to the papers at the Office of Human Rights that they have on her. You can download those from, the papers at the Office of Disciplinary Counsel under the D.C. Court of Appeals. Check it. We're naming names. We're looking at Match.com. Match.com seems to be deplatforming black men, according to an investigation underway in the United Kingdom. If you're a black man in the United Kingdom, watch out. Even if you're a British citizen, we have evidence that Match.com will take discredited testimony that is discredited and use it to block black men from the platform, according to the person who came to us seeking an investigation. We're looking at Match.com here on the Call to Justice. We're looking at Forbes. We're looking at Forbes, the accounting giant, and we want to know why Forbes did not accommodate a Latina whom they took medical information from and then turned around and fired her with the medical information that they obtained during a mediation that was supposed to be in good faith. Forbes, and we want to know why Jerica, the attorney, oversaw this against this Latina at the accounting firm in Tyson's Corner. Forbes is on the hot seat at the EEOC. They're under government investigation, and they fired this Latina for raising these issues. The mediator was a retired judge, a good retired judge. A lot of judges are really good. A lot of them are really good, really smart people. They do the right thing, a lot of the judges. They're supposed to. I'm not here to talk about stuff that works correctly. You can get that on MSNBC and Fox News, where the rich people run the agenda and PR companies do it all. I'm here to warn you about the pitfalls and traps in this multiplicity of traps that you were in and knew it, but nobody could explain it. The phone lines are open. We're looking at McKesson. There are EEOC charges against the healthcare giant. A woman, a good woman innovator, a research scientist woman out of Florida has been frozen out of meetings and promotions. And according to our records and investigations so far, we're going to look at this. We're going to ask Forbes to come on here. McKesson. We're going to ask McKesson, come on here and explain why you're doing this to this white woman who's almost 70. Ageist, sexism. There is intersectionality. A black man on Match.com may have problems in England. A white woman who we would call an older worker under the Older Workers Protection statutes. The allegation under federal investigation now at the EEOC, the Florida Commission on Human Rights, that is that McKesson did it and that they have essentially raped this woman of millions in R&D. That's the claim. What on earth is going on? What is going on? The phone lines are open. And now I will put you on speaker, caller. We have a call. Caller, you are now on speaker. The lines are open. How can we help you here at the Call to Justice? You're on, caller. I'm sorry, speaker, this is a new program. Okay, caller, try again, please. Speak loudly, caller. You're on. Okay, we'll disconnect and they can call back. The phone lines, if they can get in, the phone lines are going crazy, but I have to get out some of the things that the first caller asked about. Very important. I'm going to ask the engineer to let us know how we're doing on time, because I have a dedication at the end of the program, and we're heading toward the 60-minute mark. We started a bit late on this first-ish edition. Time we end. We have a caller, and you are live on air on WBGR's The Call to Justice. Caller, how can we help you?
Yes, thank you, Attorney Jones. Can you hear me?
Yes, we can hear you, and you are mic'd. Thank you.
Attorney Jones, I wonder, could you speak to the responsibility of the National Council of Black Lawyers in terms of getting access to the Supreme Court?
Thank you. The question is, I made reference to the National Conference of Black Lawyers, where we had internal deliberations and even a draft on this case brought by attorney Sharika Robinson out of North Carolina, that the vulgarity that Judge Boyle allowed and said was colloquial according to the Supreme Court petition, and that the Fourth Circuit with that black sheep judge went along with, and that the Supreme Court threw out this week. And what we want to see, they want to demoralize the Negro people. That's what's going on. Don't you bring your black behind in court. That's what they're saying. But we're going to keep coming, because Harriet Tubman came and Nat Turner did too, God rest his soul. Nat Turner, the martyr, kept coming. He left no stone unturned. Look it up and see what I'm talking about. What did the National Conference of Black Lawyers have to do with this? They said it's time for us to become relevant again. It's time for us to stand in this case the way they stood up for abortion rights after Dobbs. They're with the National Conference of Black Lawyers, right on with the statement, real fast over abortion rights. Now, finally, they've decided to come back in with my help, in my perspective, in my connections. That's what volunteering is all about, to finally start doing black issues again. And I think the National Conference of Black Lawyers, to their credit, is finally figuring out that because many of them have been in the public interest industry that is allowed to go to the court on white people's terms, the ACLU, the NAACP, the public interest industry, the rich nonprofits that are funded by the oppressed. At times they do, but it's not all. It's not independent. They don't understand, since they work for those, including universities where they got their petitions. Now, and do black things, because we're a creek without a paddle. We've got another caller. Caller, you'll be our last caller, because we're almost out of time before the dedication and the hymn of invitation. I want the engineer to tell me what time specifically the show is to end today. Caller, you're on speaker. Quickly, how can I help you? Caller, how can I help you?
Justice Amos, I just want to thank you for what you're doing. You're doing amazing work, and I support you 100%. Keep it going.
Thank you so much. That was a word of encouragement, a word of hope. It's what keeps me going. I know that there's an attempt to beat down and disempower poor people. And a large proportion of black people are poor, although there are more poor white people than there are all black people. And poor white people actually already understand, you better not go to court trying to get money for torts. They don't even try, most of them. They already got the memo. Well, we're going to join with the poor white people now. The black people who get this thing, we're going to get into it now, and we're going to join forces. That's why I'm a political independent. A lot of our Republican brothers and sisters know about this rigged two-tiered system where they can trump up a bunch of charges on big people they don't like and make it look like you did something that should be prosecuted all over the place. And you be using black DAs to carry their water. But a black DA or a black judge won't let the nigga be effed in the A, won't let that go to court, but they can go out there and run right out and get death threats to do the white left bidding. Shame on you. You're not worthy to walk into a Thurgood Marshall courthouse. By the way, we're going to get into the Second Circuit Federal Court of Appeals and how that's become a racially hostile work environment, we learned. the Second Circuit Court of Appeals. Yeah, I have a phone call from the clerk of that court we're going to expose this fall. And I'm going to propose that they change the name of that courthouse from the Thurgood Marshall Courthouse to the Justice Taney Courthouse, who wrote the opinion in Dred Scott. Because it's Thurgood Marshall in name only. Thurgood Marshall, even though he was an FBI informant, directly to J. Edgar Hoover in his office, as J. Edgar Hoover ran the COINTELPRO program, which the Washington Post reported on. This is not Radical Amos. This is the white, rich Katharine Graham Washington Post with the reporter Betty Metzger, my professor at Columbia, who broke it as a young reporter in the 70s, that liberal white professor spoke COINTELPRO. That COINTELPRO and J. Edgar Hoover, that's who Thurgood Marshall was rolling with, and at the same time, Thurgood Marshall was doing good civil rights work. And his reward was right up there on the Supreme Court that just dissed Sharika and her black male client. We're getting into it all. Everybody needs to know the truth. I'm waiting for a text from my engineer to tell me what time it ends, but for now we can put up the dedication. I lost my mother on April 11th. God rest her soul. K. Frances Grimes Jones. My mother was an incredible woman. She was the husband, her husband was Lamont Jones Sr. She was the wife for what would have been 60 years if she had lived 17 more days. And Kay Grimes Jones passed. She went on to glory. She had a peaceful transition. She was ill. It was a heart condition in the end, and she opted not to have open heart surgery. So we knew she was going to go within a year probably, and after about 4.5 months she got another birthday. She turned 83 in February. She was diagnosed in January, and she died peacefully and satisfied. So the show is dedicated to, this program is dedicated to my late mother, Kay Grimes Jones. And on that, we honor her and her legacy. I will post her obituary on our media platforms, as well as the hymn of invitation that appears to have been missed. I think we're out of time on the hymn of invitation, which is the hymn sung at the dedication of my mother and father's gravesite. Daddy is still alive in 84, going strong. We spoke yesterday afternoon in Kentucky. And so we had a dedication of the monument in the Lexington Cemetery, and we'll post the hymn of invitation. He Leadeth Me was the hymn on that service on Memorial Day weekend this year in Lexington, Kentucky. So I thank you for your time. I wish we could have gotten into more. There's a lot going on. Stay tuned. God bless you and yours. And if we are still on the air, then I invite you to enjoy the All Saints Cathedral, a special choir on the Lux Aeterna song service from several weeks ago. The All Saints Anglican Cathedral of Nairobi will close us out with the beautiful hymn, He Leadeth Me, which is out of Psalm 23 and has a wonderful history that I will share on our platforms since we didn't get to talk as long today. But I close out on a wonderful rendition of He Leadeth Me, a wonderful tune about the assurance God gives us, as I invite all of you, black people, white people, poor, rich, middle class, working class, people of different identities, rich, poor, white, black, Democrat, Republican, Independent, Green Party people, Dr. Cornell West Independent, come and repent and join us in this cause of justice in the tradition of our hero, Dr. Martin Luther King Jr., and many others, including white rabbis and white ministers and fundamentalist preachers and all Muslims, Malcolm X, and all of them. We invite you to turn back toward the way of justice. We close with the hymn of invitation. Good day.